There is no police department in the United States, to my knowledge, that owns an M1A1 tank, or an M1 or an M1A2. Some of them have the MRAPs, and those are the trucks that are heavily armored that were used in Iraq and Afghanistan. And others use different types of wheeled armored personnel carriers in parts of their operations. And to the extent that the use of that equipment overwhelms a suspect inside of a house and prevents the use of any weapons or any violence from them, is good, not just for the suspect and for law enforcement, but for everybody else who lives around that house. People seem to forget that interactions between law enforcement and suspects also involve everybody living around that block. Suspects don't shoot as discriminately as police officers are trained to do. Now, are there instances in which police officers shoot indiscriminately? Sure. We have over 12,000 municipal law enforcement agencies in the United States and over 3,000 sheriff's departments. I dare say that I don't think we get to 10% of those departments in anything cited in the law review article or the book that would allow the kind of generalizations that keep getting used against law enforcement. Those instances in which you have abuse of power or the use of force are issues for local police departments to address, and for the citizens of those local agencies to insist on accountability as well. They can be addressed in that regard. But they're not the same problems for local law enforcement throughout the country. And I think it's intellectually inaccurate to try to draw such broad conclusions. Now, how are the police and the military different? A soldier never has to read someone their rights before giving them a butt stroke to the head with their rifle, and there will be no use of force review. A police officer does not have rules of engagement to follow. They have state statutes and the constitutions to follow. The military has tanks. Enough about that. Police at best have armored personnel carriers. And I got to underscore, can't the media ever get this right? Just because you've got an armor plate on something, it doesn't make it a tank. The military can fire in entire areas indiscriminately, both direct and indirect, using missiles, bombs, laser-guided munitions, when battlefield conditions warrant. Police may not without risk of criminal prosecution. And even use of force statutes in many states, including the one in Arizona, requires there to be a very specific authorized use of force in order for law enforcement to have the county attorney's office here in Arizona find that the use of force was constitutional. But even then, this is something that I want everybody to understand. Even if my office in reviewing an officer-involved shooting finds that there was not a violation of the law as the Constitution would require, that does not exempt the police officer from further review for violating internal police policies that are a reflection of what the local communities expect their police departments to adhere to in use of force. The military are directed by the President, Secretary of Defense, and provided material support by Congress. Local police are paid by towns and cities with police chiefs accountable to mayors and councils. The military's jurisdiction is global. Local police are limited by state law to either their specific jurisdiction, not to exceed even in the most expansive state boundaries. The military are trained to kill. Local police are trained to arrest. Local police use tasers. The military has no use for a taser unless you develop a model that has a kill switch. The military can detain an enemy POW for an indeterminate period of time and not worry about TV, the book cart, the ACLU, or conjugal visits. Police have fixed time periods, specific charges, and holding cell requirements. Our military does not need a warrant before clearing enemy territory. Local police must have judicial authorization to comply with the Fourth Amendment. The military is housed on bases. Local police live in their homes and neighborhoods along with their fellow citizens. There is a difference between military personnel and civilians. There is no difference between citizens who serve as police and citizens who are served. For the examples I've given, I know there are instances where local police have exceeded their authority and behaved improperly. But there are sanctions for police officers not behaving like police officers and behaving like someone in the military, but that does not equate to becoming militarized. Now, there are many things that are very admirable about the warrior that I would be quite happy for every law enforcement officer, whether a man or a woman, to adopt and make a part of their character. The fact that there is a code you live by in serving others, that you do not jeopardize or that you do not run against. It's a guard against corruption. It's a guard against forgetting that you serve a higher purpose. And in some of the worst instances for them, it's what motivates them to put their life on the line to save people they don't even know. There is a nobility to policing, and to the extent that it is equated to the military in the sense of professionalism and soldiership, that's not a bad thing. Where we should be concerned and where we should be on guard is if there is a broader federal effort to blur the distinction between federal law enforcement and local police. Even in instances where there are drug task forces or any other type of task force that has coordination and cooperation between federal and local authorities, the key there has got to be that there is still a distinction between the level of authorization and the tools available. And most, if not all of those task forces still operate along those lines, where you're not going to see that kind of a distinction. I happen to sit on the executive subcommittee of our local high-intensity drug trafficking area task force. And I can tell you that when it comes to measuring outcomes and success as to which task forces are going to get funds, there is no measure of asset forfeiture. There is no measure of just on raw numbers of either drugs seized, cash seized, or number of arrests. We look at the impact as to whether or not there's really an effect on the crime rate. And that's where the focal point ought to be. If whatever operations you're engaged in do not enhance public safety, then the first question has got to be, why are we spending any money on it in the first instance? And if we're not having a positive impact on the crime rate, driving that down, then the question ought to be, what needs to be done in order to have a better effect in that area? We're not going to turn back the clock to ever go back to a day where policing is left to individual citizens. We moved to the professionalization of policing and even of prosecution because it was part of that system that if you had the money and the time, you could ensure that someone was arrested and convicted. But if you didn't, if you weren't able to raise the populace with a hue and a cry, then your victimization went unaddressed. That's no way to have a consistent justice system in our society today, nor would I argue wasn't necessarily fair at that time either. The last point I'll make to it, and this primarily addresses maybe a couple of points, depending on how much time I've got. 5 minutes, okay, maybe 2 minutes. The effort to try, and this is specifically the law review articles, to suggest that the type of policing we have today is inconsistent with what our founders conceived of is a complete misunderstanding of what happened when we created a federal constitution. The fact that that constitution does not address police efforts at all means that it was not a power delegated to the federal government by the states or by the citizens. Therefore, the 10th Amendment is in operation. So by the 10th Amendment then, it was the states that would have the realm in which to decide how to police neighborhoods and how to address crime. The founders could have cared less. It's not until the early 1920s when the U.S. Supreme Court started emphasizing incorporation of the Bill of Rights and applied them to the states did you ever have a specific legal principle in which the Fourth and Fifth Amendment was then going to be applied for state action and not just the federal government. So bad history, bad analysis, and suspect footnotes and citations do not make for a good argument. So the law review article itself, quite frankly, Seton Hall should be embarrassed for having printed it. And if it had been submitted to me as the associate article editor to review, I wouldn't have approved it for publication because the cites in it are pathetic. For instance, one of the citations in an effort to establish the principle of your integrity to make decisions for your person as an overarching principle is cherry-picked out of a California Supreme Court case that dealt with an inmate who wanted to refuse medical treatment. That footnote addresses an argument that you have the right to resist an arrest. Not very good scholarship, not very logical. There are issues too with some of the footnotes, even in the Warrior Cop book too. There's one particular reference to comments made by Ronald Reagan, and if you check the footnote, references remarks made in October 1982. The citation, those words aren't even in the remarks. I looked them up. They're not there. There are other estimates for numbers involving SWAT actions that are based on estimates from interviews of other people. And lastly, too, it's hard to accept generalizations and some of the points made to support arguments about militarization of police and what SWAT agencies are doing when simple fact checks before reporting on things here in Maricopa County couldn't even be done. And I'll give you a couple of specifics. This was posted by Mr. Balko on November 21st of 2013 at 10:42 a.m. and is a response to Death Penalty Information Center addressing counties where there are a number of death penalty cases. And it references the investigative series by the Arizona Republic on prosecutor misconduct from October 29th, and inaccurately qualifying what the Arizona Republic reported, mentions one installment devoted solely to former Maricopa County Prosecutor Juan Martinez. Juan's still working there, and was working there at that time. It mentions that Martinez had been cited for misconduct by Arizona courts 3 times in the last year. That's patently false. A simple search of the database on the Arizona Republic's website would have shown that. There have not been 3 instances of misconduct in 2012. Additionally, alleging prosecutorial misconduct, as the Arizona Republic was told, but failed to acknowledge as a regular tactic by capital defense litigators. And the writer of that series has a dislike for Mr. Martinez. Additionally, there's a reference to the exoneration of Ray Crone, referenced as one of the more notorious exonerations from Maricopa County. To my knowledge, there's only been 1 exoneration as that word is properly used. So if there are more exonerations, no one in Maricopa County is aware of it. Lastly, a more broad and inaccurate reference that I would not, a quote from the web posting, "I refuse to release any prosecutor personnel files for the Arizona Republic investigation, even if prosecutor is no longer on the job. To do so," I said, "wouldn't be in the best interest of justice." There were 2 files requested, both in cases that are actively being prosecuted. Therefore, ER 3.6, because prosecutors have ethical rules, would not allow me to release it because those cases are being actively prosecuted. And I declined to provide them while they're being actively prosecuted, but I told the reporter that as soon as those cases are done, it will be provided. And I also argued against the new rule trying to impose additional responsibilities for prosecutors involving claims of innocence because we didn't need the rule, we were already doing it. And I took offense that I needed to have a new rule to tell me to be ethical and to be a good prosecutor. Without that rule, on our own, without input from defense attorneys or from judges, we dismissed 14 cases where we inaccurately cited a statute that had been changed by the legislature, and on our own filed motions to vacate 14 of those convictions. So while I had the opportunity, I thought I'd clarify that record. Thank you.
Yeah, where to begin? First, I mean, look, that blog post was reference to the Arizona Republic article. I did not fact check that article. I didn't write it. I didn't edit it. I'm not sure why you're bringing up prosecutorial misconduct and holding me responsible for allegations that another journalist made errors. I just referenced the article in a blog post on prosecutorial misconduct. So, when I talk about the federalism issue, I point this out in the book. I mean, the explosion in the number and frequency of use of SWAT teams are driven by federal policies. I agree that criminal justice should primarily be a local issue, all of them as use of the 14th Amendment, and I think the federal government has a responsibility to make sure that local officials are respecting the rights of the citizens as protected in the Bill of Rights. Beyond that, I think criminal justice should be a local issue, and this is part of my criticism on this issue, is that the federal government, particularly in the 1980s and 1990s, created these financial incentives that push policing in a direction that it wouldn't have otherwise gone. So I actually agree on this point, that I think the federal government is much different, that the federal criminal justice policy should be kept distinct from local criminal justice policy. My criticism is that it hasn't. As far as the argument that these are individual abuses of power in some of these cases, look, this is policy in a lot of police agencies. St. Louis County, Missouri, last year there was a raid on a couple of people suspected of, it was a administrative raid for a white-collar crime. St. Louis County sent out the SWAT team. Local media went to the spokesman for St. Louis County Police Department. St. Louis County Police Department told the local TV station that now in St. Louis County, every single warrant is served with the SWAT team regardless of the crime. That's now the default. These aren't individual officers, this is a matter of policy in a lot of police agencies across the country. When I talked about the shift during the Reagan administration from reserving these kinds of tactics for emergency situations, the shift is dramatic. It was a very dramatic shift in the way that this kind of force is used in this country. You are no longer using this kind of force to diffuse an already violent situation. You're now creating, when you're sending a SWAT team into somebody's home in the middle of the night, you're creating violence and confrontation where there was none before. You're not sending these elite police teams in to apprehend someone who is in the process of committing a violent crime. You're now sending them in to serve search warrants on people who are merely still suspected of non-violent crimes. This is a dramatic shift in this kind of force, and it's a matter of policy. It's not individual officers acting out. I do think there's a difference between elbow pads and grenade launchers. On the Third Amendment, there's actually plenty of scholarship on the Third Amendment about what was behind the Third Amendment debate when the Constitution was during the Constitutional Convention. There actually wasn't any quartering to speak of British troops in colonial America. There was some once the revolution started, but leading up to the revolution, there was not any actual quartering. Now, what happened was Britain had passed laws allowing for the quartering of troops, and it was sort of an antagonistic move toward the colonists, particularly the more rebellious ones. But the Third Amendment, the Fourth Amendment, the Second Amendment, you could even argue, were a reaction against the stationing of British troops in the streets of the cities, particularly in Boston, in the general warrants, the writs of assistance that they were given that gave them broad powers to search the residents of colonists pretty much anytime they want, although unlike today, they were banned from serving these warrants at night. But these were broad search warrants. This is what led to the animosity and the violence between the citizens of Boston and the British soldiers. This is what made the founders very worried about the idea of a standing army, an internal standing army, and this is the debate between the Federalists and the Anti-Federalists. But there wasn't actually a lot of quartering going on at the time. If you read the scholarship, two of the historians that I cited in the book said there wasn't any until the American Revolution actually began. On tanks, I mean, I could be wrong, but I remember specifically with the raid involving Steven Seagal, where they drove the police vehicle of some kind into the guy's living room who was suspected of cockfighting. I saw a video of that vehicle. It certainly had a gun turret. I don't think it was, I think it may have been cut off. I didn't see if it actually had tracks. But it certainly had a gun turret, a rotating gun turret. It certainly looked like a tank, and I know the difference between an APD and a tank from the top up. I do know for a fact that Richland County, South Carolina has a tank, and I've reported on several other jurisdictions that do actually have tanks, including tracks and gun turrets that they got through the 1033 program. Finally, well, actually I have a few more things. And we talk about that this makes things safer for everyone inside. You know, if we look back at the Jose Guarena case, which is also here in Arizona, the police in that case, you know, this was a guy who was suspected of some sort of drug crime. In fact, it was his brother that appears to have been running the operation. But they conducted this raid first thing in the morning. He just, you know, wakes up to the sound of people breaking into his house. He's holding his rifle. They open fire on him. He had actually exercised good trigger control. The safety on his gun was still on when the police officer opened fire and killed him. There were bullets that actually went through that house, the outside of the house, and into the homes of neighbors. There was a child and his wife were in that house when they opened fire on him. These kinds of tactics, again, there's a very low margin for error. They're very volatile. When you're using them particularly on drug crimes, you're creating unnecessarily violence and confrontation in situations like we had in the Guarena case. Internal policies, this idea that the internal policies are somehow more stringent than the constitutional limits on police. I haven't seen it in my reporting. I mentioned earlier today the Jonathan Ayers case, the pastor in Georgia. In that particular case, the Georgia Bureau of Investigation, the local police department, and the local prosecutor all did their own investigations. Every one of them cleared the police officer who shot Jonathan Ayers. In fact, the prosecutor said the Georgia Bureau of Investigation investigation into the case was the most thorough he had ever seen in a police officer-involved shooting. When Ayers' widow filed a lawsuit, their investigator found out that the police officer who shot and killed Jonathan Ayers was not even authorized to carry a handgun in the state of Georgia. He had not taken the lethal force classes required by Georgia state law that enabled him to use a gun. It's bad enough that he was put on this task force when he hadn't had that training in the first place, but then you have 3 separate bodies that do investigations into this high-profile police shooting, and none of them can uncover that particular fact. Makes me question the thoroughness of a lot of these internal investigations. Finally, I'll have to check the footnote on Reagan. I'm sure it was just I probably referenced the wrong speech, but if you want to point out exactly where in the book it is, I'd be happy to look it up. I do take allegations that I'm deliberately misleading people pretty seriously. That's all I have. Thank you.